Under Section 1322B of the United States Bankruptcy Code, a Chapter 13 bankruptcy plan may cure a debtor's default, but it may not modify the rights of certain secured creditors. In Anderson v. Hancock, the court considered whether a bankruptcy plan's attempt to cure a debtor's default on a residential mortgage loan by changing the agreed-upon default interest rate constituted a permissible cure or an impermissible modification. William Anderson and Danni Jernigan purchased a home in Raleigh, North Carolina from Wayne and Tina Hancock. The Hancocks provided a loan to Anderson and Jernigan for the purchase, and Anderson and Jernigan executed a promissory note agreeing to make monthly payments at a 5% interest rate over a 30-year term. The promissory note also provided that any failure by Anderson and Jernigan to make a payment within 30 days of the due date would result in default and would increase the interest rate to 7% for the remainder of the loan. Anderson and Jernigan eventually missed a payment, and the Hancocks informed them that their interest rate was increased to 7%. After Anderson and Jernigan failed to make any further payments, the Hancocks initiated foreclosure proceedings. In turn, Anderson and Jernigan filed a Chapter 13 bankruptcy petition, which automatically stayed the foreclosure. They submitted a bankruptcy plan, proposing to pay their pre-petition arrears and post-petition payments based on the original 5% interest rate. But the Hancocks asserted that the arrears from the time of the default and the post-petition payments should have been calculated using the 7% default interest rate pursuant to the promissory note. The bankruptcy court agreed, rejecting Anderson and Jernigan's argument that the default and resulting increased interest rate could be cured by bankruptcy. The bankruptcy court instead held that changing the default interest rate constituted an impermissible modification under Section 1322b2. The United States District Court for the Eastern District of North Carolina affirmed, and Anderson and Jernigan appealed to the Fourth Circuit.